Hello everybody and welcome to History Bite number 58, dated September 30th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Methods of Constitutional Interpretation. This History Bite will cover the primary methods used by judges, lawyers, and legal scholars in interpreting the U.S. Constitution. These methods are very distinct, virtually non-overlapping for all intents and purposes. None of them are foolproof. Each has its own advantages, disadvantages, pros, and cons, okay? As I explain each of them, you will see what the pluses versus the downsides are. And if you don't already have an opinion of what the best methodology is, you will likely have some thought at the end over what you think is the best methodology for interpreting the U.S. Constitution. Personally, I don't think any of them should be used 100% of the time, as different situations often require different strategies, okay? So, let's get started. When it comes to interpreting the U.S. Constitution, there are three distinct schools of thought which prevail. The first school consists of Originalists. The second school consists of Textualists, and the third school consists of loose Constructionists, all right? To begin with the Originalists, this is a very distinct group which feels that the entire U.S. Constitution, from Article 1, okay, to Amendment 27, should be interpreted based on the intent of those who wrote them. All right, so Article 1 through Amendment 27, Originalists are always looking backwards, okay? They are looking to find the original intent, original meaning of those provisions from those who drafted them, or as it was understood at the time it was drafted, okay? So, with Originalists, there are two distinct schools of thought in itself. You have those who subscribe to original intent, and then those who subscribe to original meaning. Original intent theorists look to discern the intent of the authors of the provisions, okay, to discern what the true meaning is. And original meaning theorists look to the original meaning of those words at the time they were drafted. They're not necessarily concerned with the intent of the drafters per se, but what those words would have meant or how they would have been understood, not just by judges, lawyers, academics, and other prominent people of the time, but by the common person, okay, to discern what those words truly meant, okay? So, these two are very distinct schools of thought within the school of originalism, all right? So originalists are always looking backwards when they interpret the Constitution. They're not looking at the present day and certainly not looking down the road, all right? Notable originalists on the U.S. Supreme Court are Justices Clarence Thomas and Neil Gorsuch, okay? That takes us to school of thought number 2, which consists of textualists. Textualists, okay, look to the plain meaning of the text in front of them in contemporary terms to decide what a provision of the Constitution means. They don't care or obsess about things like intent or what it originally meant 200 years ago, and don't look forward either. They look at what the present day contemporary meaning of the text is in front of them, all right? And they follow the rigid letter of the text, okay? This type of strict construction or strict interpretation, they feel, is the best way, obviously, to discern what the law in front of them means, okay? As to these individuals, obviously looking backwards can lead to confusion because intent might have meant 50 different things, especially if the law was drafted by a legislative body, okay, rather than a single individual, okay? So, they feel that the strict and plain meaning of the text in front of them, all right, is what the law itself means, okay? They don't typically look backwards or look forwards, all right? Their focus is more on the contemporary, okay? So notable textualists on the Supreme Court included the late Justices Hugo Black and Antonin Scalia, all right? So that takes us to school of thought number 3, the loose constructionists, okay? Loose constructionists believe that the Constitution is a living, breathing document, okay? And its provisions were naturally designed by the framers to be so broad and inclusive that they would naturally evolve, that the meaning of those provisions, rather, would naturally evolve with the times without the need for formal amendment, okay? And loose constructionists obviously believe that our ever-changing society and constantly evolving legal precedents require that the courts, through their decisions, keep the meaning of the Constitution's provisions up to date and in tune with the times. Okay? Now, of these 3 schools of thought, all right, like I said, all of them have their advantages and their disadvantages. But the school of thought which arguably comes under attack the most is obviously the loose construction theory, as it is perceived to be a green light for judges to essentially write their own policy preferences into the law, regardless of the law's original or true intent, or what it currently means today, okay, or what it was intended to mean in any way, shape, or form. They feel that judges who believe in loose construction have the ability to write the law as they want it to mean, okay, even if that was something wholeheartedly divorced from what the law was intended to convey, okay, thus leading to charges of judicial activism. And if you've never heard that expression, though I highly doubt you've never heard it, especially in the modern era, judicial activism is essentially what I just said, when judges, okay, through their decisions, write the law, interpret the law, to reach conclusions which suit their own personal policy preferences, and not hardly in any way what the law was originally intended to convey, or how it is currently being interpreted, all right? And so judicial activism essentially is a very undemocratic thing in the eyes of most, because it allows judges to substitute their own policy preferences against those of the people. It is seen as undemocratic, okay? Of course, that is certainly debatable, and it will certainly get different opinions based on virtually everybody you talk to, all right? So those are the 3 schools of constitutional thought, okay? Originalist decisions, thus, almost always would be to the right, as they are looking backwards, okay? They're not in the modern day, nor are they looking in the future, all right? Textualist decisions, based on their rigid contemporary interpretation of a text, based on what it means right now, today, all right, can be left or right, okay? As depending on what the issue is, it could obviously lead in either direction. And loose construction interpretations of the Constitution obviously are going to be looking left, because these constructionists are typically looking to the future, okay? They certainly have no qualms about broad progressive holdings, which often take the provisions of the Constitution into hemispheres that they might never have been intended to go, all right? So, like I said at the beginning, each of these schools of thoughts have their own pros and cons, and strictly adhering to any one of them could be disastrous for democracy, as well as for the integrity of the judiciary itself. So, you be the judge. You decide which is best in terms of how you think the courts should interpret the law. Like I said, to me, there is no perfect philosophy. No right or wrong answer. Each of them arguably has merit, okay? And none of them should be used all the time, all right? The judiciary must remain above politics, in my opinion. And judges who rigidly adhere to any one of these philosophies will certainly come under attack from the side that opposes them, okay? Originalists almost always come under attack from the left, all right? Progressive or loose constructionists will always come under attack from the right. So like I said, there's no perfect right or wrong answer here. So you decide which methodology you think is best. And if you would do me the favor, let me know in the comments. All right, so if you have any questions, controversies, put them in the comments below. I hope you learned a little bit from this with respect to how judges, lawyers, and legal scholars interpret the U.S. Constitution. Thanks for listening to this History Bite. Okay, take care, stay safe out there, and I'll talk to you at the next one. Peace.